Hi, thanks for tuning in and welcome to Lunch with Particular. I'm Deb McGargle, and today I wanted to talk about terms and conditions. And I know that I've covered this many times on the site, but I wanted to relate actually to a query which came in from a client of ours earlier this week, and actually it comes in quite often. And that is the panic buy when it comes to terms and conditions. So the phone call normally goes something like this. Hi Deb, we're on the cusp of signing a major deal with a massive customer and I need a contract in place. How much is it going to cost? I'm shaking my head just because, as I've discussed in other podcasts, how long is a piece of string? And I've talked in other podcasts about the benefits of good terms and conditions and not doing a cut and paste job off Google and so on and so forth. But this brings a slightly different angle to the use of terms and conditions. If you are entering into a contract with somebody who's quite an established player, really quite a big customer, I reckon 90% of the time they're going to have their own terms and conditions, and therefore if you come into me to get terms and conditions drafted and I say, yeah, that's fine, I'll do it, and it's going to cost you this amount of money, then really I'm wasting my time and I'm wasting your time, because the customer could well turn around and say, well, actually, we're going to go ahead with the terms that we always use. So I think the first piece of advice that I give, and that I would give normally, is that these people who you're having a discussion with, I would get back on the phone and say, look, I know we're nearing to finalising a deal now, and just so we don't hold anything up, can you just send me through your contract or your terms and conditions so I can start to have a look over them? And the chances are they'll probably say, yeah, that's fine. The procurement department or the purchasing department will send those through to you to have a look at. And you'll come back to me and say, thanks very much, Deb, you've just saved me a fortune and you were absolutely right. If they don't say that and they say, actually, I thought we were going to do business on your terms and conditions, then you can panic, pick the phone back up and say, Deb, you were completely wrong and I need some drafted. But with bigger customers, bigger players, I tend to find that they do carry their own. Even if they don't carry their own, a lot of the time they would carry industry standard documents as well. There's a lot of legal documents in the marketplace that big associations have put together already. So off the top of my head, one that I've just dealt with recently is to do with plant hiring plant, and there's actually an industry standard set of terms and conditions that if you haven't got a contract yourself, you can just say to your customer that applies. Nevertheless, so in the event that your customer has got terms and conditions and then they're sent through, that would be the point at which I would contact your solicitor and say to them, can you do a review of these terms and conditions? Now, what they're probably going to send through to you is T's and C's that would apply whether or not you were buying a pencil or you were buying a jacuzzi. Not that we do a lot of selling of jacuzzis, it's the first thing that came into the top of my head. But you see my point, they're just very, very wide terms of procurement, terms of purchase. And you might think, well, actually, that's great, but they don't really apply to what it is we're doing. We're selling them a website, or we're giving them some lingerie or so on and so forth, so it doesn't really apply. The terms can still apply in principle because they'll cover things like payment, they'll cover things like what you're on the hook for, what you can be sued for, when things should be delivered, what happens if they're not delivered. So they do apply to a certain extent. Excuse me. But they might apply to the real nitty-gritty. But don't worry about that. I would suggest that you engage with a lawyer at that point. It'll be a lot cheaper than having the contract drafted that you were originally going to do. This tea's really hot. So yes, I would suggest that you engage with a lawyer at that time. Any changes that you want to make, either to the wording of the agreement. So say, for example, if you want to be paid within 10 days or 14 days instead of 30 days, you can make those changes. Don't be drawing all over their document, because they won't like that. But your lawyer or you yourself, just make changes on a separate bit of paper, call it a schedule. And equally, if the agreement doesn't cover, because often the problem is it's not about what is covered, it's about what's not covered. If it doesn't cover really key parts of the delivery between you and your customer, then again, put that in the schedule. And then you can go back to your customer and say, actually, we've accepted your terms subject to these changes, and the agreement, the contract, becomes their terms and conditions plus the amendments at the back. So it's a really easy way. It's best value for the money that you've got. You haven't just thrown money away on getting a contract drafted that you didn't really need, and it's going to make things an awful lot quicker. So, do you always need terms and conditions? Well, it's a difficult one, isn't it? You know, I should be saying yes, and that's fine, and we'll get all your lawyers to get them drafted. But, excuse me, you're just starting out, you've got a limited pot of cash. I don't want you to make stupid mistakes by getting daft terms and conditions off the internet. I'm not saying that. What I'm saying is ask your customer, because they'll send theirs through 9 out of 10 times, and then we know what we're working with. You're just forking out the money for somebody to review them, not for them to be drafted from scratch. The other difficulty as well is if we get them drafted from scratch, you're going to end up with a set of terms and conditions that really just apply to the one customer, because that's where we'll be focused in our minds. Well, it's all about what we're delivering for them. But your business offering, or the way that you do business, or your business model itself, can change over time. So don't panic by terms and conditions. Think about the money in the bank. Think about being savvy with that money, and think about asking the right questions of your customer, because it can save you a whole lot of worry, and net you a nice bank statement as well. So I think that's about it, really. Enjoy the rest of your lunch. I hope that's been useful. And I've been Deb McGargle, and you've been watching Particular.